Me too. A while ago, a law professor for Case Western University and co-director of program in law and ethics, medicine. She will present us a work on the Disability Act, the Federal Disability Protection Act, that's the right name, and the challenge of big data. The floor is yours, and we are listening.
Great. So thank you so much for inviting me. It's a real privilege to be here and share some thoughts with you for the afternoon. So I'm going to be talking about big data, artificial intelligence, and discrimination. And you have a flyer, I have a book that addresses a whole bunch of these topics, so you might be interested in looking at that. And this talk is based on an article that I wrote that I think may or may not have been distributed, but I'll talk about it thoroughly, so don't worry if you didn't read it. So in order to not leave you in suspense, I thought I would just summarize the primary argument and then we'll build it and develop it. So in the United States, and I believe also in Israel, we have a whole lot of laws that prohibit disability discrimination. And so you might think that at least on paper, we have pretty comprehensive protection against disability discrimination. And my argument is that in this era of big data and artificial intelligence, that is no longer true. And it's no longer true because all of these laws do not reach predictions of future disabilities. So the laws prohibit discrimination based on existing disabilities or past disabilities, but they do nothing to address a situation where an employer or somebody else takes discriminatory action based on suspicion or prediction that somebody is going to get sick in the future. And in this era of big data and artificial intelligence, we have a lot of ability to make those kinds of predictions. And so at bottom, I think that we need to relook at these anti-discrimination laws and modify them. All right, so now we will build that argument. So first of all, what is big data and artificial intelligence? So it turns out it's not very easy to define big data. In 2014, there was an article in Forbes, which is a very respectable magazine in the United States, and it was entitled 12 Big Data Definitions, What's Yours? 12 Big Data Definitions. But a very basic definition of big data revolves around the 3 V's: volume, variety, and velocity. So big data is very large data collections, high volume, and they contain diverse information, therefore variety, and they are ever-changing, ever-growing, and therefore velocity. Velocity means speed, okay? So you can think of it as high volume, variety, and velocity data collections. What is artificial intelligence? Artificial intelligence has to do with machines, or computers more specifically, mimicking human cognitive functions such as learning and problem solving. So you feed the computer a whole lot of information, and it learns to make inferences. It uses algorithms, it learns to reach conclusions and make predictions. That's artificial intelligence. Some people prefer to call it machine learning, in fact. All right, so why might third parties, such as employers or others, be interested in predictions about people's health that come from big data or artificial intelligence? And there are a lot of reasons. I'm going to focus on employers in this talk, but I'll mention a few other interested parties. But for the sake of simplicity, we'll focus on employers. Employers want productive workers. They want workers who are not going to have absenteeism problems, because that's going to cost money. And at least in the United States, the most important reason is health insurance, because the majority of Americans get health insurers through employers. And so employers care a lot about the health costs of their employees. So they are extremely motivated to select people who are going to be healthy and who are not going to have a lot of health insurance costs or a lot of medical costs. Now, the same is true for lenders, right? Banks want borrowers who are going to be healthy and not default on their loans. Insurers, not only health insurers, life insurers, disability insurers, long-term care insurers. I don't know how much of that we have in Israel, but in the United States, insurance is a huge business. They all want low-risk clients. So if something could tell them what illnesses people will get or not get in the future, that is very valuable information for them. And I just read an article about landlords. Apparently, landlords are interested in health information. They don't want disabled residents. They want to make sure people can pay their rent and don't make trouble because of disabilities. So the list goes on and on and on. Everyone is interested in health data if they can get it. All right, so going back to focusing on employers. How do employers get medical big data about applicants and employees? The traditional way is through medical examinations and inquiries. And I'll talk about each of these in turn, but in Israel, do employers require applicants to go through a medical exam?
Depends.
Depends on what, where.
Sometimes, but they might catch on.
Yeah. But you have to take into consideration that the system in Israel is completely different. We don't have a private health insurance.
Right, yes.
It's the government,
Well
and
aware.
the government has to give you insurance.
Right. Yes. Social media. So social media is a very rich source of big data. Wellness programs. Do they have wellness programs here where the employers try to get you to be healthier?
Okay.
Okay.
Not enough.
Okay. Well, there are big
High-tech
questions about
companies.
it.
Yeah.
And then data brokers. So there's a whole industry of data brokers who will actually sell information. All right, so medical, yeah,
What kind of examination usually the employer?
so I'm getting to that,
Cool.
right? Good
Yeah, sorry.
bridge question. All right, so we have the Americans with Disabilities Act, and it has a provision that's our major disability law in the United States. There's a whole provision that deals with medical examinations. I think here that's less important, so I looked at the law and I didn't see a similar provision. But in the United States, it breaks examinations into 3 stages. Okay, so there are 3 stages of employment. Before an offer is extended, employers are prohibited from asking any medical questions or conducting any medical examinations. They can ask people to demonstrate job tasks. So if it's a data entry job, they can ask people, please type, even if that reveals that there's some problem with the hands or with the eyes. but they can't ask directly. All right, between the offer and the commencement of employment, there's a window of opportunity for employers that is almost, but not completely, unrestricted. And so employers do all sorts of medical examinations. They can do psychiatric examinations. They can ask for blood tests. If it's heavy labor, they ask for back x-rays very routinely because they don't want people who might get injured. They can do eye exams, any kind of exams they want, except for genetic exams. We have a law, the Genetic Information Non-Discrimination Act, that prohibits employers from gathering genetic information. But other than that, they can do absolutely anything that they want. Yes?
Can they, based on the results, retract the offer?
Right. So they can, if the reason presumably is that you're not qualified, right? You are trying to be a pilot and your vision isn't good, you're not qualified. They are not supposed to do that in a discriminatory way. So if you have some disability that does not impact job performance, they're not supposed to retract the offer. And the clever thing about this is that you already have an offer. So if the offer all of a sudden is taken away, presumably you're going to know it's because of something that happened in the medical exam. But I used to work in the Equal Employment Opportunity Commission, which is the enforcement agency for the federal anti-discrimination laws. And we would see all of a sudden the employer says, oh, we decided we don't have the money to fill this position. Interesting, right? We lost authority to fill this position after they did this medical exam. Once the person is employed, the employer can do medical exams, but they all have to be job related. So at stage 2, it's unrestricted. At stage 3, it has to be job related. Now, early in my career, I wrote an article that questioned that distinction. Why should it be so liberal at stage 2 and limited to job related at stage 3? I think it should always be job related. Why does the employer need to know anything not job related? But as happens all too often with what I write, nobody listened. This distinction survives. All right, so that is medical exams. And yes, employers are very motivated to do this because of... Okay.
No, sorry. No, I wanted to ask at the end of your
At
statement.
the end of your, this
The
statement
sta-
or
I
the
didn't-
talk?
This
No,
one.
This one, okay,
Yes.
I will spit it out. So,
I did not want to interrupt, and I just did.
multiple times. Okay, so I think I was just saying, right, in the United States, health insurance is a big issue, but really it's a big issue also because of productivity problems, absenteeism problems, right? If you hire somebody and it turns out they have a disability and they can't do the job well, or they have a mental disability, they can't get along with people, employers are worried about that. That is problematic even if you're not worrying about health insurance. So it is relevant no matter what the health insurance situation is. Yes?
There are non-direct genetic questions like how many women died from breast cancer in the family.
Right. So that's an excellent point. In America, it's the Genetic Information Non-Discrimination Act, and it explicitly prohibits family history questions. I think in Israel, it's just tests,
DNA
right?
testing.
DNA testing.
If
No,
you do a biochemical test for genetic testing, like phenylketonuria, is excluded from the common law. There's a proposal to revise the law, because it's a way to get you into genetic information. Basically, it's DNA testing.
Right, so you
Yeah,
can
but the
ask.
definition of DNA testing, I think it's, I just looked at a few weeks ago, I think the definition is unclear. What is DNA testing?
No.
They define it,
Can you ask can an employer ask in Israel, how many people in your family died of breast cancer?
I think so.
Yeah, I think so
that
too.
you can-
Yeah.
Yeah,
So here it's a problem.
yeah.
This is one area where America's a little better. Most of the time we're not better, but okay, yeah.
Can they ask for your history of medical, your medical history?
Yes, at that stage too, they can. They can ask, list all your surgeries, list all your illnesses. Yeah, and genetic information does not include things that have already manifested, so they only include genetic abnormalities. If you already have an condition, it's not genetic information anymore.
We have a very strong protection of patients' rights.
Mm-hmm.
But when there's no doctor or provider-patient relationship, there is in this sense, ironically, little protection.
Mhm.
The data is not protected. If you are a patient, you are protected. But those who owe this protection to you are your care providers.
Caregivers,
That's
right,
how-
not the record.
The patient, exactly.
Okay,
Genetic information, a specific law, is about DNA testing. That's what
Right.
it says.
I think I even have a slide about it. It is the, חוק מידע גנטי.
נכון, חוק מידע גנטי 2000, and the Knesset is deliberating for many years a revision that would address this issue as well.
Mhm.
That has to do, that leads to genetic information. It doesn't
Right.
point the specific test that might lead to this information.
Right.
But it's not been voted on. It's there.
Yeah, out in cyberspace.
If I understood well, if you already have a genetic problem that is known and you have diagnosis, then it's not genetic information?
Right. If you already have breast cancer, for example, even if it's related to a genetic abnormality, the fact that you have that genetic abnormality is genetic information. The fact that you have breast cancer is not genetic information.
But if you know that you are a carrier of BRCA,
Then it's genetic information.
Can I say something? That there is a correction to the genetic information law, genetic information law from 2014 that says that an employer won't ask an employee genetic information or to go through a genetic testing.
Yes, but
So
in the
that's-
definition of the law, it has not been changed that the genetic testing is the DNA. The part that the definition of genetic information in the preamble to the law is DNA testing has not been changed.
Right. It's
So it's your DNA. DNA is protected if you test it directly.
okay.
זה לא כתוב שם?
זה כתוב, but it also talks not only about genetic testing, it talks about genetic information, which is, I think, wider than DNA.
All right. So let's go on to the fun topic of social media. So employers can and do scour social media for information about applicants and employees. And there have been instances where they have fired people based on what they have found in social media. And so there was one story, for example, in the news of a person who had shoulder surgery and then he took a long medical leave and he foolishly started posting photographs on
Okay.
Facebook, right, of his vacations during this medical leave. He got fired, he actually sued and he said, privacy violation, wrongful discharge. The court said, you deserve to be fired. So, I have heard that some employers require employees to friend them. Is that
Friend them, yeah, we know that.
Require that? That's
yes?
rich.
There's nothing illegal about it now.
But do they have to have Facebook? Like you can say I.
If you have it.
If you have it, I don't have it, so, yeah,
So
we're.
you just have two accounts, one for your employer,
Yeah.
one for
Yeah.
friends, right?
That's right, yeah, and the employer one, you say, it is midnight, I am working. Right, okay. Interestingly, you don't need direct information from Facebook. Even your Facebook likes are illuminating. So there's a research study where researchers recruited 60,000 Facebook users and they looked at their Facebook likes. And from those likes, they were able to reach conclusions about sexual orientation, ethnicity, religious and political views, IQ, happiness, addiction, age, and gender, just from what people liked on Facebook. So be careful what you like. All right. Wellness programs. So these are extremely popular in the United States. I assume more popular than here. 83% of firms with 200 plus employees have wellness programs in the United States. My university has a wellness program. 59% of wellness programs include a health risk assessment, where the employer actually takes, in my case, they take a blood sample, they weigh you, they measure your waist. I'm glad I did it before the trip to Israel. Too many ugot, maniot, hummus, yeah. And so they get all sorts of information through these wellness programs. They also, some of them give Fitbits. Are Fitbits popular here?
Yeah.
Anyway, in the United States, everybody is trying to get 10,000 steps. That's the goal.
Yeah, we do too.
Magic number.
Yeah.
So, Fitbits, but Fitbits gather information. It's not just on your wrist, it goes to a Fitbit vendor, right? And so all of this information goes to wellness vendors, and in many cases, they then disclose it back to the employer, because the employer has paid good money for this wellness program. They want to know about their employees. Sometimes they disclose just summary information or de-identified information. We'll talk about de-identification in a minute. Sometimes employers get direct information, especially if they're smaller and they don't use a wellness vendor. They may get direct information. So you participate in this program, maybe you get discounts on something, membership to the gym. You're feeding the employer information. All right, so because there's a lot of information out there, and because it's valuable to third parties, we have an emerging industry of data brokers. Are there data brokers in Israel? Don't know.
Not in this room.
Yeah.
Not, okay, we hope.
To the best of our knowledge. Right? No.
אני לא יודע, לא.
But if somebody seeks the information for you.
Let's hear it out and then see if we have it.
Anyway,
No, of course, like lists of databases and things like that. Of course we do. We must have it.
so by some accounts, there are hundreds or thousands of data brokers in existence. And they gather information, organize information, process information, and then sell it to third parties. So there is a well-known one in the United States called Axiom. And Axiom says on its website that it has data regarding all but a small percentage of US households, and this information is used to make 12% of the nation's direct marketing sales. So in the United States, we are inundated by all kinds of marketing material, and often you think, wow, this really does seem to fit my needs and interests. And it's because there are these data brokers at work. And I don't know, I sometimes do a Google search and then for months afterwards, advertisements pop up, right? And I gave a lecture in Indiana about 1.5 years ago, and there was someone from Axiom in the same program, and I asked her, I had read about this, I said, is it true that you sell lists of people identified by name and the illnesses they have? And she said, oh, privacy, we prioritize privacy, we do all these things to protect privacy, it's our highest value. And then she admitted that for the right price, you can get those lists saying so, and these are his illnesses. Very frightening. Another data broker called Spokeo says that it's a people search engine that organizes white page listings, public records, and social network information into simple profiles to help you safely find and learn about people.
Have those companies ever been sued?
I think they probably have been, but they're not stealing it. They are looking at information that is publicly available, like your social media. In the United States, we have voter registration records that have a lot of information, etc. And then they sell it. You know, they can learn a lot.
Yeah.
We have several of those in Israel, even just for legal cases. People use the database of the Supreme Court or the general court system, which is open. They use the database of the police and so on. And then if you're searching somebody, you might find cases. And then if you're interested, you're going to pay them money. And so it could be very easily misused as well. If you're going to pay them just to have your name removed, for instance, then they're making money just because you want to protect your own good name. It's a very interesting, and it's not illegal. It's just really upsetting.
Right.
I think it's even more complicated, and I agree. I looked once for a person I knew. I knew something was wrong with him. I entered Nevo. It's a sort of
It's a legal database. Yeah.
legal database, and I looked for cases that he was involved in. And in one case, he was guilty of taking his girlfriend, which was unconscious, in a car.
Okay.
And then he admitted, and all of this is written, and you can address it, that he is under psychiatric treatment and he takes this and these pills, and he himself was not completely. Okay,
Yeah.
so and this is in open with his name, with everything.
Yeah, but this is a little bit different because we're not talking about data brokers. We're just it's a little bit different. I
Yeah,
think.
it is.
This is a database,
This is
but
what they
it's-
do. They take the
No, they could, because Nevo is collecting all the court cases that are not concealed. This is different because
Yeah, but a broker could use that.
that's what I'm saying. Right?
Yeah, yeah.
Exactly.
I was
And then sell it.
Yeah,
I was
exactly.
supporting your argument.
Right. So they're misusing what is like more. Yeah.
Yes, yes. So I mentioned data de-identification. Sometimes the data that is available is de-identified. But you have to understand that de-identification itself is a very iffy proposition. You can never completely eliminate the risk of data re-identification. So, in the United States, we have a very famous privacy law. It is called the HIPAA Privacy Rule. And it applies to healthcare providers, healthcare insurers, and healthcare clearinghouses. Those are billing people. Okay? If you're one of those, the law says that if you want to disclose data to other parties without the patient's consent, you have to remove 18 identifiers. So that's a lot, right? Name, telephone number, identification number, patient number, et cetera, et cetera. But still, experts have tried and succeeded, even with the 18 identifiers removed, in re-identifying at least a small percentage of record collections. How do you re-identify? All you have to do is link de-identified information to information that has some identifiers. So let's say you have a hospital record that is completely de-identified, and it says person X had his leg amputated on such and such a day, and then provides details. And then there's a newspaper article that says the name of the person, he was in a terrible motorcycle accident, and as a result, he had to have his leg amputated at such and such a hospital on this date. Boom, you have re-identified all of those hospital records, and you know every detail of that treatment, what happened to the person. Okay, so that is re-identification. Now, the terrifying thing is that if you're not a healthcare provider or insurer in the United States, you don't have to remove 18 identifiers. It's much more liberal. And the studies show us that 80% or more, between 80 and 90% of the population, can be identified by 3 factors alone. If you have sex, zip code, and birth date, it is very easy to identify people. That combination is unique to most people. So you don't need the name, you don't need the telephone number, you just need sex, zip code, and birth date. So if people tell you, oh, don't worry, your privacy is protected, this record is de-identified, you have to worry, what exactly does that mean? The other thing that can happen with de-identified records is that employers, bankers, landlords, and so on can build profiles based on de-identified data of people who are undesirable. All right, so in the United States, we have the Centers for Disease Control and Prevention, and they provide a very good website that allows people to do research. It's called CDC Wonder, a lovely name. And you can do searches, for example, for the prevalence of certain diseases in certain population groups. So you can search for cancer, and you can see black women over 50, what is the prevalence, and white women under 50, whatever. You can narrow your searches. Well, nothing is to stop an employer, lender, whoever, from doing those kinds of searches and then deciding that they don't want to hire or accept women who are black and over 50 or whatever, because they're worried about their health risks. So they can just build profiles based on de-identified records. All right, so that's another discrimination concern. So why am I worried about disease prediction? Well, we have a lot of ability to predict diseases. You can know a lot about people's health status without even worrying about what diseases they have now. So we know that there are some very straightforward things, like a causal link between smoking and a lot of health risks, right? Lung cancer, other cancers, heart problems, etc. And so in my city, I live in Cleveland. The Cleveland Clinic, which is a very famous medical center, will not hire smokers. And if you're a very fancy doctor or fellow, they might enroll you in a smoking cessation program. But if you fail that, or if they don't bother enrolling you, you cannot get hired if you're a smoker, right? is largely because of concern about future health risks. Women who haven't had children are at higher risk of breast and ovarian cancer. Nothing is to stop an employer or anyone else from denying women who are childless of various opportunities, right? That is not disability discrimination. Researchers are also working very hard to identify biomarkers that these are physical traits that are associated with diseases. So in one study, they found that lower levels of 10 phospholipids in the blood indicate that the person will develop cognitive decline in the near future. So the employer can say, I'm just taking a blood test, and you think, okay, they're checking cholesterol or whatever, and they're looking to see if you will develop cognitive decline in the near future.
A paper in Nature Medicine from yesterday shows that your face can identify specific mutations you have.
There you go. They can just look at you.
They'll be first.
Right? There's also a lot of studies with the eyes. So small changes in blood vessels in the eye at age 60 have been found to predict memory loss over the next couple of decades. So, right, the employer or whoever can say, I'm just doing an eye exam, and they're looking for these blood vessel changes. All right, and artificial, there's also other interesting predictors, right? They've done studies, people who make purchases in bicycle shops, obviously, are healthier than others. And so I tell my students when they're looking for a job, it doesn't hurt. Go buy something in a bicycle shop. In the United States, we have presidential elections every 4 years. We have midterm elections every 2 years. Traditionally, not this time, but traditionally, people don't vote in the midterm election. So if they do, studies have shown they're usually healthier than other people because they have the leisure to follow politics and to get involved. People who are too stressed about their lives don't do that. Credit scores, right? Employers can get credit scores. Obviously, a good credit score, you're likely to be healthier. A poor credit score, you're likely to be unhealthy. Maybe your medical problems are giving you the poor credit score, and if not, you're not able to fill prescriptions, get follow-up care, etc. in the United States, where you have to pay for everything. All right. Artificial intelligence has brought this all to a new level. So deep learning algorithms are used to predict heart disease based, again, on analysis of the retinas. So in America, we have a saying, the eyes are the window to the heart. Now it turns out they're the window to your entire health history and status. So, machine learning algorithms are used to predict the risk of heart disease, stroke, and diabetes based on electronic health records. So your electronic health records can tell people what problems you have now, but with machine learning, they can also tell people what problems you will develop in the future. And artificial intelligence has been used to model the speech patterns of patients at high risk of psychosis. So just listening to how people talk can be illuminating with respect to their psychiatric health or future psychiatric health. So all sorts of capabilities now with artificial intelligence.
Question?
Yeah.
Electronic health records are protected in any way? Because it's good to have a prediction algorithm, but if it's not allowed to use this data.
Right. So they are protected, but the patient can give consent to share them. And so in the United States, where employers do a lot of testing, they will routinely ask the person, please authorize me to get your electronic health records. We need to make sure you're qualified for this job. And the point of this is that once they have the electronic health record, they can do any of this. They can be sitting and just trying to analyze whether you're at risk of all these future illnesses. So it's protected as long as, but people can be asked to provide authority. And also remember, if it's de-identified, it's not protected. It can be used for research and so on. And what does de-identification mean? Yeah.
But the thing is, I think when they can't ask for genetic test, it's because the genetic ability to predict something in the future.
Right.
For example, many of the genetic markers aren't binary, like 1 or 0.
Mm-hmm.
You will have breast cancer with such
Right, you're at such and such a risk, percentage risk.
Yeah,
of,
like
yeah.
the base for ignoring giving DNA testing, it's the same reason for the usage of machine learning right now, or for machine learning above electronic health records.
Correct, but you don't need genetic information is the point. You can use the eyes, the blood, etc. And an employer or lender or landlord or whoever isn't going to care what I think the term is penetration, what the percentage chance is. If they're going to see, oh, this person has some chance of developing whatever, they'll say thank you and they'll go to the next applicant. And so that is the risk. And a lot of people, even expert doctors, misinterpret genetic tests. So they don't always understand that it's just such and such a percentage risk. They'll say, it came out positive. So, all right.
Will you give some time when you finish?
We can do it now or when I finish. I'm happy. I'm here to serve. So whenever people want.
Because my real basic question was, what is the difference between big data, and I'm a computer person, so I'm not, I'm aware of, they used to call it data mining, now they call it big data, but it's the same thing. Mm-hmm. What do you find as difference between big data and just looking at textbooks for doctors which say, okay, if you have cholesterol, you will be at risk of having heart disease. I don't see, I mean, at the end of the day,
right.
So morally and practically, you look at it at the same thing. The only thing I can say about big data, that first of all, if you put garbage in, you get garbage out. Mm-hmm. So most of the things, and I think as a doctor you would say, if I come with such a theory as, I don't know, if you eat too much when you're young, you will be too skinny, or if you're too skinny at a young age, you will have osteoporosis, etc. I think all these things have to be established, and just looking at big data, I think as a doctor you would say, okay, nice, but it's a theory, and until you have a clinical trial,
correct.
It's like, okay, everybody can say stuff like after looking at big data.
That is correct, but since we're concerned here about discrimination, these capabilities, big data and artificial intelligence, have brought the predictive initiatives to a much higher level than just saying, okay, you smoke or you have high cholesterol. So there's more and more and more that people are doing, looking at retinas, looking at electronic health records, looking at speech patterns. And the employers are going to, or whoever, are going to be fed all of this information and are just going to say, okay, we only want Superman.
At the end of the day, they will be left with nobody. Because most of us will get the...
I want to develop this a little. I try to. There's some counter arguments. I apply for a job and They realize that I'm likely to have a heart attack in the future, and they move on. And then they check Noam, and they see that's horrible other diseases he might develop. So they move on. And at the end of it, every job applicant will have his dark profiles looming in the future. Also the positive profiles, and into it you would factor performance. And at the end, this industry will drown under excess of data. So if there is a risk that you know about of stigma, like psychiatric disease or people with HIV, you are concerned about this information, because this one could be one person with HIV might be excluded. But when you go to the big data era and about predictions of the future, everybody will carry something on one shoulder. Now, when we have research on how people get jobs, there are lots of non-rational and irrational elements in it. Those that are taller have greater likelihood to get a job than that are shorter. Good-looking people. So current practices and habits, conscious and unconscious, let alone plenty of workshops and experts that tell you or evaluate by exams who is going to be a good doctor, a good employee, and nothing is evidence-based. So it might be the substitution of one unfounded methodology of astrology by another. But at the end, it's difficult to persuade us, maybe I'm trying to challenge that the discrimination issue when everybody is involved. You cannot be anti-Semitic when everybody is Jewish. So your anti-Semitism has no... So when at the end everybody has something, this is what I targeted. So maybe, I'm trying to think in a little absurd way, when the market is open to all kinds of testing and you don't limit it, every prejudice will be neutralized by the next. What do you think about this possibility?
Right. So that is an excellent point. I suspect that they're not going to do all of the testing. For example, we've been so concerned about genetic testing. It turns out there isn't genetic discrimination very much because it's too expensive to do genetic testing on an applicant. They don't even know if they're going to be hired.
And it's too uncertain.
And it's too uncertain.
That's the point.
So I'm not saying they're going to do all of this, but probably eventually some methods will emerge that are not very expensive and are more reliable. And I doubt very much that all of this that is being developed is not going to have any practical application. It's just too valuable for third parties. And also people have the diseases that they are more afraid of. So they might not be that afraid of heart attacks because lots of people survive them, but they are afraid of cancer. So they're going to try to identify those, or they're very afraid of mental health problems.
Oh, this is the issue. So
and
if
cognitive.
you, as a lawyer or regulator, you pinpoint mental health, it becomes meaningful when you liberate other areas. That's exactly the point. Otherwise, there's no meaning to it. Because the act of this is to protect people with disabilities, but by the big data, this way of looking at it, we are all disabled, if
Right.
not in past or in the present, in the future.
Correct.
But
Well, not
it's-
everyone.
I want to claim that you can rank the disabilities, and it's going to become very easy to do it and very cheap as well.
Right.
We sequenced the first human genome in our lab. It cost us $20,000 5 years ago. Now we do it for $500. In 2 years, $50. And we're getting better in bioinformatics. So it's going to become easier. And then we'll start ranking the disabilities.
I think the question is not how expensive it is. I think the question should be, is the data reliable? In
Right.
the sense that, and I think what Michael started to say, you take evidence-based medicine, which is statistical, and you try to impose it on a singular person. How much chance do you have to really know that this person is going to develop heart attack?
But
No,
this
but
is a statistical question. You're in a company, you are going to employ 1,000 people. If you are reducing, if the statistics is that you choose the people with the lower risk, then over the population.
No, but you are not choosing screws for a machine that all identical. There will be a gradient of risk for heart attack, then gradient for performance, and gradient for reliability. And the risk that somebody may perpetuate sexual harassment at the workplace. You can try to graduate this, but certain markers, there's no end to it. Because people are multifactorial.
Of course,
and that's,
but still
so at the end of the day, you stay with nobody.
Okay, they take longer.
it is no national, that says no rational basis to
different
it.
factors that determine long risk. Eventually, they sum it all up and they come up with a threshold. And they will do the same here.
But it's meaningless, that's what I'm saying. It's meaningless. It's maybe no worse than current practices of hiring people that go by hunch, by prejudice, by somebody that knows how to talk nicely to you, or you feel well in a job interview. It's substituting one shaky science by another.
Well, but eventually some of these will be reliable enough that it will be like deciding not to hire smokers, which is done in the United States.
Yeah, what about not hiring people who eat a lot of hamburgers, which is also, full of fat
Well,
and.
the wellness programs are trying to get people to stop eating hamburgers.
I would suggest that the idea should be, and I think it's morally also correct, that do not use predictive data for hiring people. Whatsoever,
That is what I'm
no
about to
matter,
suggest.
no matter.
You can't steal that. I was about to say that. So
Okay.
I'm not saying we can't do this.
Of course you can, but you shouldn't.
No, I'm not saying people shouldn't do this predictive work. Let them do it. Fine. Gesundheit. But so my point is, it shouldn't be a basis for decision making.
By the way, some people can smoke all their lives and they will
And
not
nothing,
get,
right.
and
Because they
that
have a
means that
genetic-
genetics could also come to aid these people
Correct.
into getting a job.
To clinically get a job with the
But then
So it works both ways,
And
but you can rank
HIV
it.
also, there are a few
Yeah.
people that don't.
And the
Okay.
other thing is that maybe you should take Obamacare into consideration and stop this.
It's dead.
Yeah, I know.
Now it's Trump care.
Because of but the idea is become a little bit more of a welfare
I wish.
country and less
Libertarian, yeah.
Excuse me, before you move on,
Yeah.
I just want to say that I think it's of course a good idea to say that employers shouldn't take this into the consideration when hiring. Okay, that's a good thing to say, but I think that even today, test for women who are pregnant, actions are being today already being done for predictions of disease. So actions are being made already. So we can say that maybe, I think at some point this information will be used, whether, you can say, employees should say without בלי הבדלי גזע דת ומין ובלי הבדלים של prediction, but I think that even today we can see that people make choices based on a predictive, so okay, they look at genetics, and today when you do a genetic chip, which gives you a whole lot of information that gives you no ability to choose or to understand really what you're doing, saying you do the emotional. So I think that it is a real problem, even if we say that okay, maybe this is not the correct information, that is maybe only a theory and so on. I think that eventually those things are taken into an account of somebody's actions. So I think we should be concerned about it and think how.
Yeah, but the idea is that this is the law, and you want to establish something in the law saying you should not use it, at least not openly and not directly, and make it open if you do use it, because of all the moral and the scientific arguments which say that it is not reliable enough, and it is not at the end of the day it will not give you enough.
It's not an argument. It might be reliable enough. Then your argument
It
is
cannot be reliable if you say that a person, okay, that has some genetic problem has 20% of becoming such and such. How can it be reliable if you now look at me, I have this genetic problem, and you say you have 20% of. So what?
It's
So
reliable.
will I get it or will I not?
20%.
People
But
are
at
doing,
the end of the day, will I be sick or not?
but
You
people are
don't
doing actions
know.
according
You will
to
know when I die if I had the disease or not.
So
So you understand that
Yeah,
coming from statistics, you cannot say on a person something that is reliable.
But
No,
the day.
No, it's true, different
It's
words.
the basis of
Right.
the thing itself.
and my answer first of all, the number 20%. You can evaluate if it's a reliable number or not. It's a number,
Right.
But
and
it doesn't
you.
give you anything.
That's another question.
People
It's
are
the reliable.
No, this is
No,
just
but the terms you're using is
Yeah, the
it's
term
not the
you're
right
using.
one.
I
There
don't
are
find it
two- let
accurate.
me a
But
second.
just a second. The second part of my answer, which I think is more interesting, is that when you use multivariative analysis, for example, I take a look at your gene, your specific gene, and your psychological status, and your eating habits, and your blood test for the last 20 years, and your over and over and over and more data, I can create much more accurate model, and the percentage that you will have cancer or not will be much more reliable, in your words, and much more reflect your chances to have, touch wood, this disease or the other disease. And I think that would be better and better.
But then let me put some more information into it, okay? Now that say I have a BRCA, okay, and my chances of getting ovarian cancer are 99%, and we have it in the family, by the way. I skipped it.
Okay.
But all my cousins had their ovaries removed, so they will not get ovarian cancer. So what
don't
is
know.
your
Okay,
information
so-
now?
No,
These
for
days, now it's 5%
Yeah.
instead of 95%.
Okay, so
So you understand that what you're
no,
saying
but I can
is
model it. The first question will be,
it's
do you
endless.
have,
You can
not
repeat
endless.
and it goes.
No.
You understand what I'm
It's not
saying?
endless at all.
Let's a second.
It's fixed.
Let's
You
keep
can find fixed number of variables that will help you to model it.
Yeah, but you cannot
Let-
make a decision.
Wait.
based
Let's
on it.
maybe get back to the.
Yeah. I want just to put things by proper definition. The accuracy of judgment is always problem contextualized. So if we are talking about hiring one person or 5 person, it means nothing, the numbers, you are right. If I'm going to hire 5,000 people, we can have models in which not hiring certain kind of people will decrease the chances of having cancer in the workplace. This is an example. Now, when we face the individual person, he's never been evaluated solely for one healthcare industries or solely for health. He's here for a job because the person is qualified for a job. And he has his own or her own qualifications about the job. And we are about to cross some medical statistics whose relevance to the person may vary, and some may not be, they will be mathematically reliable, but not reliable practically, because there is no way to translate a 10 or 20% chances of having cancer on one particular employee. It's meaningful for a long service employee. And then you need to factor it with completely different and incommensurate elements, personality, adequacy for the job, and the synthesis here has no algorithm behind it, because the question of the employer at the end would be to get a good job. Maybe one day somebody comes up with the strongest algorithm forever that you tell you that if you put in the machine, tell you how much money you will get at the end of the day as the bottom line for hiring a certain person. And even if this works, we will not be able to know by the big data way of processing the artificial intelligence what is the factor that made it profitable, that he's good at his job because the person is less sick. We will just be enslaved to the numbers. We are moving in this direction to a kind of extreme empiricism. So this extreme empiricism poses many theoretical and moral problems, but it does not pose an issue of discrimination, because if there is any discrimination, it's hidden inside the mysteries of the artificial intelligence machine that knows nothing. We are innocent. We know nothing about it. And it will be even difficult to show that the machine is biased. There is research showing that certain AI machines learn the bias in society. There's been studied about it. But as long as you don't show it, I won't take too much time, but the big data cannot be too big, otherwise we all drown and lose meaning. We need to contextualize a decision is against an employer, for example. And then, as you said, there's issue discrimination. It doesn't matter whether the information is accurate or not. If I believe that you are likely to be psychotic and I don't hire you, this is discrimination.
Right. No matter whether it's right or wrong.
Even if I follow astrology, this is discrimination, if this is what I think. Okay? But we need always to isolate the element under discrimination and show that there is discrimination here and that it stands aside from other elements that I can play in.
Good. Okay. So let me just get back to my suggestions, and then we can discuss them. So the Americans with Disabilities Act, as I already mentioned, that's our primary anti-disability discrimination law, and it defines disability as follows: a physical or mental impairment that substantially limits one or more major life activities. So a current impairment or disability, a record of such an impairment, a past impairment. And this is interesting. I don't think the Israeli law has a similar provision. The American law prohibits discrimination against people who are regarded as having an impairment. So they can be perfectly healthy, but if the employer wrongly thinks they're disabled, the employer is not allowed to discriminate. So you get people with some disfigurement, scarring, or whatever. The employer doesn't hire them because the employer thinks they're disabled. That is prohibited. Or they have a limp, or something else that is fairly superficial. If the employer thinks that they have an impairment, they are protected. All right, so just to show you, I did do my research. חוק שוויון זכויות לאנשים עם מוגבלות, right, 1998. אדם עם מוגבלות, אדם עם לקות פיזית, נפשית או שכלית, לרבות קוגניטיבית, קבועה או זמנית, אשר בשלה מוגבל תפקודו באופן מהותי בתחום אחד או יותר מתחומי החיים העיקריים. So this is a current disability again, right? Nothing about predictions of future problems. We do have a law, and we've all talked about it already, the Genetic Information Non-Discrimination Act, which does prohibit discrimination based on predictive information. Genetic information is predictive, so employers and health insurers are not allowed to try to obtain genetic information except for in very limited circumstances, and if they do have it, they are not allowed to discriminate. even though this is purely predictive data, right? And so what I'm going to suggest is not a departure from this approach. In Israel, you have the same thing, חוק מידע גנטי, לא יעשה מעסיק שימוש במידע גנטי או בתוצאה של בדיקה גנטית של עובד, לרבות לעניין קבלה לעבודה, קידום בעבודה, תנאי עבודה או פיטורים.
Insurance.
Huh?
There's also
Yeah,
a section about the insurance.
Insurance, okay, yes. Okay, so this does prohibit discrimination based on predictive information. I'm just suggesting that we make the other disability laws consistent with this approach. And so in the case of the Americans With Disabilities Act, I would suggest expanding the regarded as provision, that one that you don't have here, to protect individuals who are perceived as likely to develop physical or mental impairments in the future. So that is not a big change, it's just adding a few words, but it would capture this concern. Now, we may in fact, it would be consistent with Gina, we may in fact have to add a few other qualifications. So we might want to create some exceptions. If the employee or the individual is engaging in particular risk-taking behaviors, I wouldn't encourage employers to discriminate, but we might want to have a list of behaviors that they can take into account because they're in the control of the person, presumably. Smoking, extreme sports, bungee jumping where you're going to break your head, right? Maybe we want to allow employers to consider those. So I've given this talk elsewhere and sometimes I get a lot of resistance to this suggestion, but I still think it's worth considering. And of course,
if it would be somehow related with an eccentric personality, something that might be adjacent to bipolar disorder or just hypomanic tendencies, would you say, I'm sorry, I'm protected, I do that because that's my disability, talking, it's not me, you cannot discriminate me because of that, or would that not work?
I mean, right, so that would be complicated, you can't discriminate based on the disability.
But on behaviors you can, perhaps.
Right, but
Okay.
behaviors you can. Now, there's some emerging research that maybe even smoking is related to some genetic abnormalities,
Right.
so we would have to reconsider that if that is proven. But, you know, we always want to try to balance employer autonomy, let them make some decisions, and so this is trying to moderate the proposal. It's going to be hard to detect this kind of discrimination, and so we probably need to have employers disclose certain data mining practices. And so if they are looking at social media, we might want them to tell employees. If they are purchasing information from data brokers, we might want to require them to disclose that kind of practice, either on the application form, the employee handbook, their website, whatever. So all discrimination is very, very hard to prove. I always tell my students, we're trying to get into the employer's mind and figure out what they were thinking at a particular moment when they said no, or they said, you're fired. That is extremely challenging, and this is going to be no different. But the hope of the anti-discrimination laws is that most people want to do the right thing, most people want to comply with the law. And so if we give people this kind of guidance, hopefully they don't do anything that is obviously discriminatory. They try to comply with this mandate. And I think this is a protection that people are going to need increasingly as there's more and more predictive information out there and being used, and it would allow the law to sort of catch up to technology in a useful way. So that's it. So now we can argue further. We exhausted all the arguments, I don't know.
No, I just think that what you wrote is excellent. And I wish they would look at problems like this in the same manner in other places where it's needed. And I think it's really important. Maybe it should be more, should take more situations into consideration. But such as even using a regular textbook in order to predict how you're going to behave. It doesn't have to be big data or
Yeah, I mean, the
or
language,
genetic or whatever. You
the
just look at
language doesn't say big data or artificial
Yeah.
intelligence.
You're right.
So it covers
Sorry.
everything.
You're right.
So do you have any cases that have been in, I'm sorry,
No, I'm finished.
any information about people who felt they were discriminated based on, for example, genetics or anything that's been into court? And I mean, how, like you said, it's very hard to
Right.
to
Yeah, they're
catch
just,
those.
so interestingly, actually, in the United States, the Genetic Information Non-Discrimination Act is from 2008. It took us much longer. You had one in 2000. So they had a whole bunch of articles and studies to celebrate the 10-year anniversary. It turns out there is very little, if any, evidence of actual discrimination.
Mhm.
The cases that have gone to court are all about privacy, about attempts to get information.
Right.
And so, now there's some articles that say GINA isn't a discrimination law, it's just a privacy law. So that's interesting. There are very blatant cases like smoking. So you have employers that will say, we do not hire people based on smoking, it's not good for our patients, it's not the kind of employee we want.
I wish to
But,
go on.
no, somebody did something with recommendations. I mean, you know that in some states or
No, they listen to me in seminars. I
Go
don't
home and
know.
smoke.
Yeah, exactly.
it's went to court or to government
Not yet.
or
There's always hope. In the United States, much bigger country, we have 320 million people all saying what they think. So I'm one of them, but there's always a dream that I will impact. I think some of the things that I wrote about that privacy rule, the HIPAA privacy rule, did reach higher. But now we have, it's not easy in the United States government right now. So I think this is not the key concern.
I think we should also be worried not about the employers' part, because they might be controlled in the future. It's about the data brokers that can use it both sides. They can use it as a service for the employers, but they can also take advantage of the employees by giving another kind of service of any interventional service. I'm coming from IVF unit, so I'm all the time wondering about what kind of genetic intervention we will do in the future in order to improve the chances for different aspects of life, including employment, but it can also for other things or other interests in human life. So they are not controlled, and we should worry more about them and about their ability to manipulate the information and also to choose which kind of data to include in each file or profile of any human being.
Right, so that would be a whole different privacy law again, but that is a concern.
I'm more worried about it than the employers.
So you're talking about Big Brother rather than big data.
Yes.
In Israel, I don't know if anybody's aware of this, but they're working now on a continuous medical record that will
Follow you from,
throughout your life. And they're really towards the end of this process of finishing
Talk
developing
about
this.
the OFAC system?
No, it's not
It's
official
something we've done.
Yeah.
And the United Systems in the hospital is
But
very
it's not
worrying
working.
in a way.
But
Anyhow,
Advantages but very worrying.
everybody will be opt out, not opting in.
So you have to opt out, but you have the option of opting out?
That, yeah, but I'm worried about all this database that will be, everything will be in one file and
Available.
available and. if
On the
it's,
other hand, from a risk, I'm coming from risk management, from a risk management perspective, it's the best thing ever to have your medical sequence. You can
Yes.
keep your medical
That's
sequence.
Well, we need to protect this information.
Yeah, I agree.
Yeah, I want to say maybe something about this initiative. I want to ask you a question coming from a very different direction. We are in the mood of self-protecting from big data interferences. But suppose it is possible that my employee, Tel Aviv University, with all this data mining, running a few lines of code, can tell me or can know that I may have a heart attack or similar treatable event, then there might be liability for not doing it. And this is something that, whether you have thought about it, some other people say, well, with all these algorithms for Facebook and other places of the risk of suicide or whatever may happen to a person getting into depression, then you might say, what about your duty
To disclose,
To disclose, to warn, maybe.
duty to warn.
Yes, it would be negligent not to do anything when an imminent harm, knowledge about imminent harm is accessible to you and only to you.
They can put SSRIs in your drink without you knowing.
No.
But
Yeah,
Yeah,
so
that's true.
that is
This
a
is
very,
this possibility.
it's a good question.
so that's something that people have thought about. So in the context of the Genetic Information Non-Discrimination Act, for example,
Yeah.
there are a whole bunch of cases where there are certain sensitivities, genetic sensitivities, where substances in the workplace can trigger terrible things, chemicals. And so, the employer was in a catch-22. If we test for that, that's violating the Genetic Information Non-Discrimination Act. If we don't, the person can die because we know we have this substance here and the person will get very sick. So they actually made an exception that allows employers to test for particular toxic substances in the workplace. So we may well have to address that issue as a separate issue. The duty to disclose, obviously the employer doesn't have a doctor-physician relationship with the applicant or employee, and you would have to be very careful to make sure it's reliable data, it's not a mistake, etc. But you may start getting certainly those kind of cases where, wait a second, you have you had information and you didn't warn me when I could have taken some preventive action.
Or they might say you are at risk for heart attack, for psychosis. Just we are letting you know, and we won't pay, or the minute you get heart attack, you will not be insured, or whatever. Okay, we'll have a restriction according to your future diseases.
In the US, you can't
Not the
exclude
doctor.
somebody from the health insurance group, so
Even though he has a high risk of
yeah,
becoming
In Israel, in Europe, it's the same law everywhere. But a way to get out of it might be a kind of economy of balance, that once you render those holding the data liable for disclosing at least important data that is clinical important, they will not touch it. Because the value of having medical information about people as an employer might be offset by the responsibility you carry in taking care of the person. So the issue is more of balance of responsibilities than discrimination or harm. And if this might be a way to get out of it, I'm just throwing an idea to less try to restrict employers, because they're all, as I showed in the first slide, at least in the second phase, they can get all sorts of information, and anyhow they can pass all around and say, okay, get the information you have, but if something happens and you have the information, we will find you liable for not doing something in the protection of the person.
Right, so, I mean, that's also tricky because we have part of the anti-discrimination mandate is to not be too paternalistic. There were cases where employers said, oh, we produce batteries here, so no women who are pregnant or could get pregnant can work here, which means mostly only men work there. And the women sued because they needed a job. It was the only employer in the area. And yes, the employer presumably was trying to protect their health, their fetus's health, but it was too paternalistic. So it's a very fine line because you don't want to deprive people of opportunities to support themselves, to have a job, to have a career, because of a fear that there's, whatever, a 40% chance that something bad will happen.
It's a lot, 40%.
Or 10% or whatever.
In your tort law, would that be considered to be voluntary risk-taking, so that the tort liability would not fall in the hands of the employer?
So you could create a duty to warn, and then the person signs, I accept this risk, I'm willing to work here. But then you have to worry, the employer still doesn't want that, and so they'll find a way to not
Wouldn't they
promote
anyway
them.
need to pay, even if they signed all that? Isn't it like a...
No, but they're gonna, if they are going to get the heart attack, they're gonna not work, they're gonna not be productive, they're gonna have high health insurance costs. So the minute the employer has the information, even if the person signs, I'm willing to take the risk, they're
No, that's a different story, but the question is, would would they, if I sue the employer, saying, I don't care that I signed it, I'm not going to sue you, now that I'm damaged because of working for you, you should still carry the damage. I mean, it's, you enjoyed my work, now you have to pay for
I mean,
what
there
it costs.
is a doctrine of assumption of the risk.
Right, so there is assumption of the risk, that's what I meant. Okay.
But it depends on how clear were you, did they
Right.
really knowingly assume the risk, were they, did you just put the paper and say,
Right.
sign here, etc.
Okay.
Do you know if there is any other place in the world that have this recommendation already coming into action, like Europe or?
I am totally original, nobody should doubt that, you have heard Kawami Sinai here, and
And it's going on already in the law.
I don't think there is.
No.
I'd like to ask you a question, but do you just try to think about it? If, for example, as part of the job requirement, it was written that I'm looking for some product manager with 2 years experience, knowledge in SQL and Python, and less than 60% to have heart attack in the next 5 years, and less than 75% to have colorectal cancer. As part of the job requirement.
Wow, that's interesting.
Because I guess that if the algorithms were be enabled to the employers, they also would be enabled for the for the patient, because he owns the data of himself.
Right.
So how do you? Because when I try to
Is that prohibited, is your question today?
prohibited.
It's not
Even
prohibited.
that, I don't have a like specific question. Just try
Yeah.
to
Right.
improve the.
I mean, right now, it's not illegal, I think. But in the United States, probably you would get challenged because on that regarded as provision, because they would say that's bleeding over to you're regarding him as
Mm.
there's something wrong with him already. So, but a clear reading of the language of the law, I think, would say you can do that because you understand he's totally healthy now. You don't think he's not healthy now. And so you just don't want future problems and the law doesn't reach that.
I just trying to think like in a much more moral aspect of the society. Let's assume that we have thousands of algorithms per each relevant disease that מטרידה the employers.
Concerns that.
Yeah, but and also the patient himself can run an algorithm. So what would be the effect of the society on the society when you just there were jobs that I won't be able to apply because I know that I have risk for breaking my hand, so I can't work as a
Welder or whatever.
yeah, waiter for example.
Did you see the movie Gattaca?
Yes.
So,
It's all about the.
so in a sense, you might get a job that is more suitable for you. I have a startup proposition. We're a startup nation. The next phase would be, I guess, dating apps that would, let's say I have this and that possibility of gaining such a problem. I want like peas and pod that my mate would have other problems so we can support each other, each and having problems in different times of their lives. Theoretically, that's possible. It might, it might happen. I don't know. So as a society,
The system has failed. We need to do more literature here. Because in the past, I would know a lot about my family and the family in other families, and I would get the best match for my children. It's like genetics at the social level. The social standing, the money they hold, and it all melted down by the power of romantic love. And again and again, people bond by this irrational or non-rational way of falling in love against all whatever calculations you can set for them. And if the money of the family doesn't speak to you and you go away with the woman you love, I don't think the chances of having cancer in 20 years will be more convincing. We just don't go this way. It did not work.
But in New York, some of the religious communities do genetic tests.
oh, here as well, Dore Sharim, for instance.
They do it before mating in order to avoid this kind of conflicts, knowing that once they meet, their choice what might overwhelm the situation. And don't genetic testing, you see somebody that has a parent with a major mental illness, you already know that every child has a very high chance of getting a major mental illness, and the same for diabetes. You have two parents with diabetes, the chances of a child of having diabetes 50% is a lot. I mean, the stronger numbers we have do not count for high-tech genetics. It's just, observing life. And you see also in Jewish law, there's a semi-prohibition to marry into family of epileptics. And it didn't catch. And it's the only law limiting in a eugenic way marriage. We don't go this way usually, and luckily, and I think also in the work. Anyhow, thank you for excellent seminar. We don't test our presenters for the chances of having